All right, if you're getting ready for the Queensland bar exam, you absolutely have to know this stuff cold. We're diving into civil court jurisdiction, and trust me, it's so fundamental that if you get this wrong, your case could be over before it even gets off the ground. Let's jump in.
So let's make this real. Imagine your client's in front of you. They've got a solid claim and you're ready to go. But wait, before you even think about drafting anything, you have to answer this single most important question. Which court? And this is not just some procedural hoop to jump through, it is the entire foundation of your case. I want you to think of Queensland's civil court system like a ladder. Every rung represents a different court, each with more power than the one below it. Your number one job as a barrister is to make sure you step on the right rung from the very beginning. So today, we're starting right at the bottom with the Magistrates Court. If you only remember one thing from this whole explainer about the Magistrates Court civil side, please make it this number, $150,000. This figure is literally the key that unlocks and limits everything that court can do.
And look, this isn't just a guideline. The Magistrates Courts Act actually calls this the prescribed limit, and it's a hard ceiling, a brick wall. If your claim is for $150,001, you're in the wrong place. End of story. Section 4 of the Act lays out exactly what the court can handle. And it's pretty much the bread and butter of day-to-day civil litigation, things like recovering debts, suing for damages, fighting over goods. You'll even see some specific things about partnerships and estates. But what's the one thing they all have in common? You guessed it, that unwavering $150,000 limit.
Okay, time to climb the ladder. We're taking a big step up from the Magistrates Court to the District Court of Queensland. And this is where everything, the power, the dollar amounts, and the sheer complexity of the cases takes a massive jump.
And with that huge jump in power comes a much, much bigger number, $750,000. This is the new monetary ceiling that you have to burn into your brain for the district court.
Now, just like with the Mags Court, this limit is set in stone by legislation. If you look at Section 68 of the District Court of Queensland Act, that's where you'll find it. This $750,000 monetary limit opens the door for the court to hear much larger personal actions and a whole host of other specific claims we're about to get into. But here's the thing. The District Court isn't just the Magistrates Court with a bigger price tag. No way. Section 68 gives it this hugely expanded toolkit of powers. It can hear and decide a much wider, more complex range of disputes. So let's break that down. First up, let's talk about the court's significant muscle when it comes to high-value fights over assets, land, and money. We're talking major commercial disputes and serious property law conflicts. So of course you have your personal actions, but now they're up to that $750,000 limit. But on top of that, the court can do things like enforce a mortgage, it can step in and provide relief if there's been fraud, or it can even order someone to hand back possession of land. This really shows that step up in complexity. These are serious issues, and they're all under that monetary umbrella. The court's toolkit also digs deep into the very fabric of legal relationships. Things like contracts, business partnerships, and what happens to deceased estates. This is where you see some really powerful stuff. The court can actually order someone to follow through with a contract. That's what we call specific performance. Or it can just cancel an agreement altogether. It has the power to dissolve partnerships and oversee the entire administration of a deceased person's estate, which includes hearing those really important family provision claims. These are major powers to intervene in complex personal and business matters. Okay, so if Section 68 gives the district court its toolkit, then Section 69 is the turbocharger. This section introduces a concept that is an absolute game changer. And for any aspiring barristers, you have to get your head around this, the mirror power. This right here is the golden phrase from Section 69. Just let that sink in for a second. For any matter that's properly within its financial jurisdiction, the district court can do anything the Supreme Court can do. It has the same powers, the same authority. This is a massive, massive deal. So what does this actually look like in the real world? Well, it means the district court isn't just about ordering people to pay money. It can issue powerful injunctions to stop someone from doing something. It can appoint a receiver to seize control of assets. And this is critical. It can grant those urgent emergency-style orders like a Mariva injunction to freeze a defendant's assets or an Anton Pillar order to search their premises and preserve crucial evidence. These are the sharpest tools in any litigator's arsenal, and thanks to Section 69, they are all on the table in the district court. All right, we've covered a lot. Let's boil this all down into a simple side-by-side comparison. Think of this next slide as your go-to cheat sheet when you're studying for the bar exam.
When you see it laid out like this, the difference is just night and day. First, the money, 150 grand versus 750. Huge difference. Second, the scope. You go from simple personal actions to these broad, sweeping powers over land, equity, estates, you name it. But honestly, that last row, that's the real game changer. It's not just about the money, it's about the remedies. Because of Section 69, the district court has the entire arsenal of the Supreme Court at its disposal. Injunctions, freezing orders, powers the Magistrates Court just doesn't have. So mastering these limits is going to dictate your entire strategy from day one. But the lines aren't always so clean, so I'm going to leave you with a classic bar exam problem. You've correctly filed a $100,000 claim in the Magistrates Court. Perfect. But then the defendant turns around and files a counterclaim against your client for $500,000. What happens now? Knowing the answer to that, well, that's the next rung on the ladder.